Arizona Alliance for Retired Americans, Inc. et al. Versus Crosby, English, and Judd, CB 2022-00552. It's also Kate Hobbs in her official capacity as Arizona Secretary of State versus the same defendants, CB 2022-00553. Parties, please announce your appearances.
On behalf of the Alliance for Retired Americans and Ms. Stevenson and Robin Berry from Alliance Group. And Jody Dickerson.
Your Honor, I am Tom Crosby from District 1, and I do not believe that our counsel has showed up. I have made this prepared statement, if I may.
Not yet, Mr.
Okay.
Crosby, but give me just 1 second. Okay, so I need to get everybody's appearances.
You bet.
Other appearances? Yes, Ms. Judd, go ahead.
Supervisor Judd, Cochise County, Supervisor District 3.
Thank you, Ms. Judd.
And English, Supervisor for Cochise County, District 2.
Thank you, Ms. Amy. We also have counsel present on our Zoom. Please announce your appearances.
Good afternoon, Your Honor. Andy Gaona with Coppersmith Brockelman and Bo Duell with States United Democracy Center on behalf of Secretary of State Katie Hobbs.
Good afternoon, everyone. We are set for hearing on the individual plaintiffs' special action complaints, and specifically their petitions for writ of mandamus. The first order of business for the court, Mr. Crosby, I will allow you to make your statement, but we gotta take care of some housekeeping matters first, okay, sir?
Thank you, Your Honor.
The first matter of business. Folks, I'm going to remind everyone who's listening in on our telephonic line, if you place us on hold, it plays hold music, which makes it impossible for other folks to hear. What this court will do is it will mute it so you can't hear it in this court, and we'll continue with the hearing. You will miss out on your opportunity to hear the hearing if you place it on hold or if you step away from the phone for any reason. The first order of business is Mr. Crosby, Ms. Judd, Ms. English. The court has been informed that perhaps you have hired counsel, but I have not received a notice of appearance from counsel. I do not see counsel present appearing on your behalf. Do you wish to update the court as far as the status of that matter?
Certainly.
Go ahead, Mr. Crosby.
These issues are very serious and important, and we want them adjudicated based on the timetable of these orders. We request a continuance based on inability to find counsel. However, if the court would grant a continuance until Monday or Tuesday of next week, as of 11 o'clock this morning, attorney Mr. Daniel McCauley believes he can learn enough about the case, preferably by Tuesday.
Thank you, Mr. Crosby. Am I to understand that Mr. McCauley would not be able to be prepared and appear today's date for today's hearing?
That's my understanding, and if he was, he would be here. That's what I understand.
Thank you, sir. Do plaintiffs wish to be heard? Plaintiffs here present?
Yes, Your Honor. We certainly oppose any continuance of this hearing. Any inability to secure counsel is entirely the defendant's own fault. They've been on notice for at least 10 days that this lawsuit would proceed. They were sent a letter on the 21st from the Secretary of State saying that if they did not canvass on Monday, they would be immediately sued, which they were. We, the Alliance and Stevenson also sent a letter on November 22nd, so it's been at least 10 days that the defendants have been on notice that they would be sued and that these proceedings would ensue. Of course, they're also familiar with the court's process from the former case, the hand count case that proceeded earlier this month. The lawsuit was filed hours after the unlawful actions of the board, and the court promptly set the hearing, and all of these documents were immediately searched. So we don't think there's any basis for continuing the hearing, and any hardship or difficulty that's caused is the board's own doing by not securing counsel in a timely fashion. Second, the facts in the law are clear today. There's nothing that is going to change. There's nothing that's not already properly before this court. Everything is quite clear, and the continuance would not in any way help the court decide this issue. And of course, there's a huge public interest issue here. The board is now 4 days past the deadline by which Arizona law mandates that they should have certified this election. The Secretary of State, and of course the Secretary of Council can speak more on this, but the Secretary of State has to canvass this election on Monday and may only postpone it for 3 days. In the interim, they've been unable to prepare for that. So it's very, very, very tens of thousands of voters who cast ballots in this election won't have those included in the canvas. And so the results for the statewide elections, they won't be a part of that, and their votes won't count. So that's just an incredibly dire consequence that would befall voters who've done nothing wrong should the canvas not be completed in a timely fashion. And I heard Mr. Cosby to just say that he actually wants to wait until after the Secretary plans to canvass the election, and not just plans, it's required by statute to canvass the election before even holding a hearing for this court, let alone getting an order and any subsequent appeals that come from that. So that sort of delay is just not tenable in the circumstances that we find ourselves in. Further, I think it's worth noting that it appears that the board is acting with some bad faith here. Members of the board have made public statements to news outlets describing what they're doing as a protest over the election in Maricopa County. They have openly acknowledged that this entire machine issue that has been raised since over the past 10 days was mostly a pretext for certification, and that, quote, it's the only thing we have to stand on. And so there's certainly some bad faith actions going on here that shouldn't be rewarded or allowed to proceed by delaying these proceedings further. Again, the law is clear. The board has a duty to protect the integrity of this election by following Arizona election law, and they failed to do that. And a writ has to issue to force them to complete their non-discretionary duties under Arizona law.
Ms. Maduri, when the court was assigned this matter, it issued an order directing all plaintiffs to serve the defendants with a copy of their pleadings, as well as this court's order setting today's date, setting the deadline for filing a response, and providing other information about the hearing. Did you comply with that order?
We did, Your Honor. We sent the orders to the county administrator, the county attorney, as well as the attorney that the board represented would be
Supervisors at issue here had difficulties securing an attorney willing to defend something that, frankly, has no defense. Is hardly the fault of the secretary, the plaintiffs in the other case, and to delay the case on that ground would prejudice all Arizonans, and in particular the voters of Cochise County. The canvass currently is set to take place on Monday, December 5th. The canvass requires the attendance of not only the Secretary, but the Governor, the Attorney General, and the Chief Justice of the Arizona Supreme Court, all of whom have confirmed that they will be attending the canvass that is set for Monday. It would be incredibly burdensome, if not impossible at this time, to reschedule the canvass based on this requested continuance. The Secretary has been in contact this week as this case has proceeded with representatives of the other state officials who must attend the canvass in order for it to be legal. And it's given the schedules, the very busy schedules, as you might imagine, Your Honor, of those three state officers, it may be that we cannot get all four of those officers into the same room by the December 8th date. Everybody has always operated under the assumption that the December 5th date would happen, and it needs to happen at this point. And the other thing I would raise, Your Honor, and the reason that we've requested relief be granted as of today, and that the board be ordered to hold its meeting and certify its election as of today, is that it's not just a matter of the board transmitting its canvass to the Secretary and everything is done from there. The Secretary's office has an internal administrative process that it has to go through to assemble the canvass and proof it. And as I understand it, that proofing process takes several days and involves at least 4 individuals who need to go over all the numbers with a fine-tooth comb to ensure that the Secretary is presenting to the other state officers an accurate recounting of all the votes cast in the state of Arizona. In short, Your Honor, a continuance simply cannot occur in this case, and there is no prejudice to the defendants in this case because they plainly had a non-discretionary duty to canvass this election. They plainly violated the law, and Mr. McCauley taking 4 days to get up to date on this and to present a defense that I'm not aware of that he could even come up with a defense should not be a reason to delay this and to delay the statewide canvass.
Mr. Gannon, I'm going to ask you the same question I asked Mr. Dury, which is this court ordered you to serve all of your pleadings as well as a copy of this court's order. In your case, did you follow that order? And did you serve appropriately the documents, including the deadline for the response and the order setting today's hearing?
Your Honor, we proceeded exactly along the lines as Ms. Maduri described that she did.
Mr. Crosby, do you wish to be heard further, sir?
Certainly. May I have this document passed to you, Your Honor?
It depends on what the document
Okay,
is.
this is a letter from Cochise County Attorney's Office, and this has to do with our ability or not to obtain counsel.
Well, you can. Would you like it to be marked as your exhibit number one?
Well, I'm not representing the board, so what status am I in besides being,
Your current status, sir, is as a listed defendant in the case.
okay,
I was about to rule on your motion, but if you believe that informs the court in some way
yes,
as to how it should rule on your motion to continue, the
okay,
appropriate methodology.
absolutely, yes it does.
The appropriate methodology, sir, would be to have it be marked as an exhibit.
Okay,
So do you wish to have it marked as an exhibit?
certainly, as long as I'm not trying to take the place of a lawyer, because I'm not a lawyer.
Well, Mr. Crosby, with all due respect, you do not get to put your stipulations on how this court conducts this hearing.
Absolutely.
So let me explain to you how I think the court is viewing your motion, and then you can make an educated decision as to how you wish to proceed. This court received the petition and the associated pleadings either Monday evening or Tuesday morning. For a fact, this court said on Tuesday, issued an order setting today's hearing for 1 o'clock, and ordering any responsive pleadings to be filed yesterday's date by 5 o'clock. While that was a short turnaround, probably 35 hours, it was sufficient time in this court's eyes to not only understand the nature of the proceedings, but also to acquire counsel. This hearing is going forward today. The reasons that you set forth do not constitute good cause and do not promote the interests of justice in order to continue this hearing. So your motion to continue is denied. The fact that you have not had a counsel file a notice of appearance means you are unrepresented by counsel. However, you are permitted as a listed defendant sued in your official capacity to represent yourself. If that is your choice, and if you do not wish to do that, I'm not going to require you to do that. But I want you to know, whatever your decision may be, this hearing is going forward. If you choose not to participate in the hearing, that will not be a reason for the hearing not to proceed. I understand the position that puts you in, and I do not do that lightly. However, the importance of this hearing has been noted, and the importance of resolving this issue so that the Secretary of State may go forward and so the public can understand what the procedure is of paramount importance in this court's eyes. So, you have a choice. You can represent yourself and you can submit the document about the difficulties you've had, or you can explain to the court about the difficulties that you've had in acquiring counsel. But the court is proceeding with the hearing today.
Okay,
and
then it is unnecessary.
Okay, very well. The next matter of business on the court's plate is there is a motion to consolidate these two matters because they essentially resolve around the same question. Ms. Maduri, are you seeking to consolidate?
We didn't file a motion to consolidate, but we support it, the secretary filed it, and we don't oppose it.
Mr. Gaoni, did you wish to offer any further argument in support of the motion to consolidate?
No, Your Honor, I believe the motion speaks for itself. As the court noted, the two cases raise essentially identical issues against the same defendants, and it makes good sense, particularly given that we are holding this hearing today together to have the two cases consolidated under the earliest case number.
Thank you. Mr. Crosby, do you wish to be heard?
No, sir.
Ms. Judd, do you wish to be heard? I'm sorry, ma'am? Thank you. Ms. English, do you wish to be heard?
I have no comment on that.
Thank you, Ms. English. The court having considered and read the motion to consolidate, the court finds it's proper. These two hearings will be consolidated into one matter. Given that they center around the same question, they will be consolidated in the lowest case number. We will proceed to hearing. The only other preliminary matter that the court had was that there was a motion filed to permit an amicus curiae brief. It was from a variety of individuals. The court is not going to take argument on that motion. Instead, the court, understanding the issue before it to be a relatively straightforward one, the court does not believe that amicus curiae briefs will be helpful to the court in determining the issues before it. So, understanding and respecting the voices of the folks who want to be involved in these proceedings, the court does not believe it's appropriate to consider those amicus curiae briefs and will not consider them in deciding the issues before it. So the request to be designated as amicus curiae is respectfully denied. I think that takes care of all of our preliminary matters. I don't know, Ms. Maduri or Mr. Gaona, if you had any preference as to how you wish to begin these proceedings? They are your petitions, so.
Yeah, I would perhaps make just a very brief statement, and I will confess I've actually never been in a situation where the attorney for the other side has not appeared. We did want to take some brief testimony from some of the defendants. They were subpoenaed, if the court will allow that.
Well, how you conduct the hearing is up to you. However, the court would note there is no notice of appearance filed on behalf of the defendants, so there is no counsel to recognize them on behalf. From the court's perspective, it seems like the issue before it is purely illegal. If you believe that there is testimony that is necessary to establish the certain aspects of the court must find, that's fine. But from the beginning of the hearing, it seems that the issue that's being presented is whether the canvass is required or not, what the statute requires. And it's pretty clear that there are no disputes, at least that have been presented to this court, as far as what the history of this case is. If you wish to provide testimony, I guess I can't stop you from doing it, but I'm not quite sure what the benefit of the testimony would be.
And just a moment.
You may.
Okay. Given the court statements, and we do agree this is a pure issue of law, and the facts are quite clear that the board has not canvassed the election, so we don't believe it's necessary to take testimony from the defendants that are present.
Do you wish to argue?
I think actually I probably said everything that needs to be said in response to your the motion to continue, and of course we stand on our papers, so I don't think there's anything left that really needs to be argued here.
Mr. Gaona, do you wish to be heard?
Your Honor, we do not have any witnesses to call at this point. We agree with the court that the issue before the court is a pure question of law, and the only thing I would add is or reemphasize is what I mentioned just a moment ago, that given the Secretary's processes, we would request that the court enter an order immediately requiring the board to meet today to approve its canvass. And, given the history of this case, Your Honor, we would also request, particularly because Supervisors Judd and Crosby are here, that the court should advise those supervisors of the potential consequences of their failure to comply with what we believe this court's order will be. The Secretary needs to proceed with this. Arizonans need finality. The canvass needs to proceed. There are 3 recounts that need to proceed. And at this point, enough is enough, and we need this case to come to a swift end. So, thank you.
Mr. Gaona, I understand that the Secretary's preference is that this court ordered the Board of Supervisors to meet today and to take certain action today. But I also understand the Board of Supervisors have already scheduled a meeting for tomorrow morning. What prejudice goes to the Secretary of State if the court orders them to meet as scheduled and orders them to keep that hearing on the books, so to speak? Why does it need to be today as opposed to tomorrow?
Your Honor, at this point, we're already effectively 4 days behind schedule in terms of how the Secretary had planned for this to go with staffing and going through the proofing process with the canvass I mentioned. So while it is theoretically possible to complete that process if the meeting were to occur tomorrow, it would place a significantly smaller administrative burden on the Secretary's already burdened staff who are already behind schedule for the meeting to occur today and for the canvass to be sent to her today.
Well, no disrespect intended, Mr. Gaona, but can't the Secretary and the administrative staff focus on the other counties and their ballots and their elections and prepare those and wait for the results of this county? The statute itself includes a provision of what happens if the canvass from the Secretary of State is missing certain ballots. So why can't that just be the way that this proceeds?
Your Honor, obviously, we were aware that the board has that meeting, and before this case was even filed, we were aware of that. But obviously, noticing something on its agenda, the board's agenda is not a guarantee that the board will actually follow through. In the spirit of compromise, Your Honor, I think the Secretary can accept the canvass tomorrow, provided that the court's order is clear and that there will be no more games and no more excuses, and that if the board fails to comply with the court's order, that we will be able to promptly get back before the court tomorrow to immediately institute contempt proceedings if they do not follow through.
Mr. Crosby, do you wish to address the court, sir?
I'm not sure. I could, but I don't want to pretend to represent myself or my fellow board members.
Mr. Crosby, you are not permitted to represent your fellow
Okay.
board members because you're not a licensed attorney, as you
Right.
stated. However, you have every right to represent yourself. And if there's anything that you wish the court to consider in considering the petition before it, now would be the time for you to present it.
Would that include a question like what is the definition of cannabis and what is the definition of approve or certify?
Are you asking this court to define the statute for you, sir?
Well, no, just pass. I'll just read what I have, if that's okay.
Absolutely, sir.
Okay.
The
This
floor is
is-
yours. And I want to be very clear. I am not imposing any limitation on how you present whatever it
Okay.
is you want the court to hear.
Sure.
And this is your opportunity to let the court know what you think the appropriate outcome of this case is.
Okay. In the case document ending in 553, paragraph 5, page 5, paragraph 21, the secretary recognizes two later delay dates of December 5th and December 8th. Therefore, continuance does not delay the secretary's duty. Our intention is to vote on this issue tomorrow, and there is no bad faith. The reason why it was not voted on the 26th as or last Monday, I think that was the 26th, was that the item was misagendized on the agenda, and I corrected that, and that is the corrected agenda, which you may have seen for the second.
Anything else, Mr.
No,
Cosby?
sir.
Ms. Judd?
I just wanted, well, let me get up there so you can hear me.
Please, thank you very
Wanted
much. You're very
to-
soft-spoken, so I need to be able to hear you.
Just wanted to acknowledge and thank the court for recognizing that there is a provision in the law to extend the dates. And I would have mentioned myself that there are 15 counties and we're just one, in fact, a smaller size county. So I am respectfully to the secretary that ask that she go ahead and proceed as she is. And I full well intend to meet tomorrow and be respectful of the voters in my county. So,
Ms. Judd, I don't want to put words in your mouth, but I do want to understand what you're telling the court.
okay.
What I understand you to say is that if the court allows the meeting to proceed tomorrow as scheduled, it is your intention to vote on the issue of cannabis. As scheduled. Is that what you,
Yeah.
is that what you're
Well, I
telling?
recognize the schedules and it would be my wish to do that. So we will see.
What time is the hearing set for tomorrow?
10 a.m., sir.
How long do you expect the hearing to last, Ms. Judd?
A minute, hour and a half. Yeah.
I'm just trying to figure out the timelines because I don't want to put, if I allow it to go tomorrow, I don't
We
want to
never
put a
know.
proper timeline on it. You understand?
Right.
So, a couple hours?
We aren't likely to continue a meeting to later in the date. That's not typical of our board, but I can't even say that. If we need to consult, we may stop for a few minutes, but a couple hours.
Okay, very well.
Thank you, Your
Is there
Honor.
anything else you need me to know, Ms. Judd?
Not really.
Thank you so much. Ms. English, is there anything you'd like to say?
Yes. It would be my desire that you ask the board or tell the board to meet today to certify the cannabis. I have been told by board members in the past that they would certify that day, and then it was, well, the next meeting we will certify. And so the meeting tomorrow, and the reason that they wanted to wait until tomorrow is because Supervisor Crosby has indicated in the agenda that tomorrow he would like to have sort of a smackdown between the Secretary of State and the election deniers that he has on the agenda. Each one of them are supposed to speak for 15 minutes each, and then they can give time to each other, and then he wants a recess, and then he wants the Secretary of State to come online and justify what they're doing. And so I think it's a service that doesn't need to happen. And so, I've had enough, I think the public's had enough, and so I'm asking for a swift resolution to this, if that's possible, sir.
Ms. English, admittedly, I don't know what the current composition and leadership roles of the board are, but my understanding is, at least in the past, if not presently, you are the chairperson of the board. Is that
That's correct.
Is there any difficulty that you can explain to the court, or any prejudice that the board, or you as a member of the board, would suffer if the court were to order that the board meet today and certify today?
I see that there would be no problem, because we had an emergency meeting this morning with an hour's notice in order to have the board select an attorney that was to appear at 1 o'clock today. So if you told us we had to meet today, we could set an emergency meeting, and within 1 hour we could have a meeting and certify if we were so ordered.
Is that common practice for the board, if they had to set an emergency meeting, that it be
We
that
very
short?
seldom have emergencies that require us to meet, but it seems as though this issue has caused us to have several special meetings and emergency meetings. And so normally it's not normal, but within the context of what's going on now, it seems to be becoming more normal.
Thank you, Ms. English. Anything else?
No, that's it.
Ms. Maduri, anything else from claims?
No, Your Honor, I was actually going to explain what's on the agenda for tomorrow's meeting.
Please go ahead.
It is as Ms. English just described. It sort of appears to be an effort at some kind of mini trial where election deniers from outside of this county, who are not even voters in this county, are going to come and present some sort of argument about why there are errors in voting machines, and there's sort of a face-off, I guess, set up for the Secretary of State to defend it. So we would just request, I think, we defer to the court obviously on when to order a meeting, should the court do so. We certainly think it should be done today and can be done today. And the board, as Ms. English has said, has set, I think, at least 5 sort of emergency meetings over the last few weeks for this sort of proceeding, and so it's certainly something that they're capable of. Should tomorrow's meeting be permitted to proceed, we would request that part of the court's order would be that the only item on the agenda would be to canvass, as opposed to having this sort of unnecessary testimony that is not required for the canvass to be completed.
Thank you, Ms. Maduri. Mr. Galen, is there anything else from your perspective, sir?
Your Honor, I'd only add one thing to what Ms. Maduri just said, which is that to the extent that Supervisor Crosby had imagined some sort of showdown between a host of election deniers and staff from the Secretary of State. Secretary of State has no intention of participating in such a charade, and so we would join the extent the meeting will proceed tomorrow. We would join in the request that it be limited to that single agenda item.
Thank you, Mr. Galen. Anything else? Ladies and gentlemen, what I'm going to do is I'm going to take a few minutes because I want to think about exactly how I want to word my order, but we will have a meeting today. And what that means is we're going to take 15 minutes now, and we're going to start back up at 5 minutes to 2. And at that time, the court will render its decision. If you want to stick around in the courtroom, you're certainly welcome. Obviously, if you leave the courtroom, you go through security, you risk not being able to get back in time, because we're going to start at 5 minutes till, and if you want to be part of that proceeding, you should be here. We'll stand at recess until that time. Thank you all very much. The Board of Supervisors has a non-discretionary duty to canvass the returns as provided by the county recorder or other officer in charge of elections, and has no authority to change vote totals or reject the election results. In reviewing the statute that is at issue, the court finds that language is perfectly on par and perfectly in confluence with the statute at issue. It does not contradict the statute, and it has the effect of law. From that statute and from the Elections Procedures Manual, it is clear what the Board of Supervisors is duty-bound to do. The statute unambiguously requires that the Board of Supervisors will meet no less less than 6 days and no later than 20 days, and you are to canvass the election. The only exception is if results are missing. Even with that exception, the board only has a limited ability to delay canvassing and requires the board to canvass even if after those 6 days the results are incomplete. The elections procedure manual accurately and appropriately describes the non-discretionary duty imposed upon the board. The court also notes that the Board of Supervisors only has the ability to exercise those powers specifically ceded to it by the legislature. That's Hart versus Bayless Investment, 86 Arizona 379, Supreme Court case from 1959. The County Board of Supervisors has only those powers expressly conferred by statute or as necessarily implied therefrom. That's State ex rel. Pickrell versus Downey, 102 Arizona 360 to 363, an Arizona Supreme Court case from 1967. County supervisors may exercise no powers except those specifically granted by statute and in the matter fixed by statute. That's Mojave County versus Mojave Kingdom Estates, 120 Arizona 417 at 420. Actions taken by a board of supervisors by methods unrecognized by statute are without jurisdiction and are wholly void. By statute, by elections procedural manual, and by law, the board was required to canvass the election no sooner than November 14th and no later than November 28th of this year. The only lawful purpose under which they could have delayed that canvassing requirement was if elections had not been received. However, that did not occur in this case. Instead, the members of the board voted to delay the canvass of the election due to concerns about tabulation equipment used in this election. Whatever challenge or concern that the board or its members or the public may have about the certification or licensure of the tabulating equipment is not contemplated by ARS 16642, and it is not a reason to delay a canvass. It cannot be a lawful exception to what to this court is a clear requirement that the election be canvassed by the board. Because of that, the board exceeded its lawful authority in delaying the canvass for a reason that was not permitted by the statute. The court finds ARS 16642 specifically imposes upon the board the duty to canvass the election and to do so in a specific time frame. This duty is non-discretionary. Because the board did not timely canvass the election, and because the board acted for a reason that was not contemplated by that statute, the board has exceeded its lawful authority in failing to canvass the election by today's date. Accordingly, a writ of mandamus is appropriate in this action. The court is granting both plaintiffs' requests for writs of mandamus. The court is ordering and directing the Board of Supervisors to convene today's date at 3:30 p.m. to hold a meeting of the Board of Supervisors and to canvass the election. It is further ordered that the canvass will be completed no later than 5 p.m. today's date and provided to the Secretary of State. To the extent that parties have requested that this court warn board members or warn individuals about what happens if they don't follow court orders, the court declines to accept that invitation. This court recognizes its authority, and I'm sure the parties recognize this court's authority as well. They will follow the court's orders, and if they don't, we will figure out where we go from there. But I'm not going to tell anybody what to do other than this writ of mandamus, which is, you will meet today, you will canvass the election no later than 5 o'clock. Unless this court stays this order, which it is not inclined to do, or another court intercedes, that order is firm. Are there any questions about the court's orders today's date? We stand at recess at this time. Thank you, ladies and gentlemen.
All rise.